Morning, Your Honors.
Good morning, sir.
May it please the Court, my name is Mark Hansen of the Law Offices of Lobeck and Hansen, PA in Sarasota, on behalf of the appellants SK Condominium II Association and SKBP LLC.
Very good.
There's a procedural matter I'd like to bring to your attention, something that's occurred since the briefing of the case, and that's that there was a plenary appeal of the summary judgment that was rendered by the lower court in this case, and that resulted in an appeal of that decision to this court and an affirmance. But significant to this case, which is a appeal from a final judgment for attorney's fees in favor of the developer, the court denied the developer's application for attorney's fees on appeal. So in abundance of caution, I filed a notice of supplemental authority yesterday in the law of the case precept, that being Langer versus Fells, that is very similar to the facts of this case, where there was an appeal during which there was lower court proceedings involving fees, and once the fee award came to the appellate court applied the law of the case using precedents such as SALTA 2 and denied the fees and reversed the fee award in that case based upon the law of the case doctrine. The same law was presented by motion to the court, that being the two bases in terms of Article 10C of the Master Declaration and Section 718.302, subsection 6. Both those issues were presented to this court, and again, the fee award was denied. But substantively, Your Honors, the threshold matter, fees are in derogation of the common law, and therefore they're to be strictly construed under the case law. So there's guidance of the court in these matters, and the reason for that is the strict construction. Case law provides that if it's a close case, fees are not to be awarded, and I suggest that's because of the policy underpinning of the case law using the common law.
If I could just sort of
American rule, if you will.
Focus my thoughts, and maybe you can focus your arguments, help me address my concerns. You've done a very masterful job of trying to explain the difference between a violation or by a non-complying party or a breaching party as to the master covenant, as opposed to what it was your clients were trying to do. I'm not sure I'm persuaded by that dichotomy, so I'm going to give you a chance to sort of elaborate on that, because I think that's where this case rises and falls, in my opinion.
All right, Judge, appreciate that. And so this is a de novo review. So this court does review the contractual provision, which I think you're referring to, that being Article 10C, from a standpoint of a de novo review. So there is no deference provided to the trial court, so I'd like to state that at the outset. But in terms of the fee provision, this is a very narrow fee provision in this particular contract. And there's some other cases cited by the other side that are not so narrow. And we've cited three cases that are, I think, are responsive to your inquiry, Judge, that being the Chesterfield Company, the Dan Glasso Waste Services case, and the Dade Savings and Loan case, all of which are cases that implicate or entail a breach of a contract or some form of noncompliance in an action that was brought that did not specifically invoke those provisions for noncompliance and breach.
Didn't you claim in your accounts, though, that the appellee had unlawfully retained control of the master declaration and violated the Florida statutes in that process?
Well, Judge, let's talk about that. That's a separate statute. That is the Section 302, subsection 6, and that provides for a fee for a violation of Section 718.301, which is the turnover control provision of the Florida Condominium
Take
Act.
the statute out of the equation, because I understand that difference. Okay. But you specifically in each count claim that the appellant had unlawfully retained control, and basically you were challenging that. Is that right?
Well, the challenge, well, it's, yeah, the statute, in order to address the question of, if I can first address the statute, then the substantive provision of the document, but the statute provides for turnover control upon a certain percentage of sale. And that means, so just so that Your Honor, the court is aware, what turnover control means under the statute is a election of members other than the developer. So the developer starts out in control of a condominium association or community association, and then there are certain benchmarks and protocols for transfer of that, for election by individual homeowners who, upon a certain percentage, I believe it's 90%,
But
own the majority.
Wasn't the claim that the appellant was violating the master declaration by retaining the control?
Well, the claim was that, all right, the claim was for two things. That essentially, it was asking for a merger of these two condominiums because of the disparate effects, because of the fact that 75% of these folks own the units, that they had no say in the budgetary adoption, no say in the levying of assessments. They had no rights whatsoever traditionally afforded to condominium unit owners under the Florida Condominium Act, Chapter 718. That's the dichotomy, Your Honor. What we were seeking to do is right the wrong that had been created by this inequitable and unlawful scheme of development by fashioning a means of providing all residents with a form of representation through a creation of master association or merger of the two condominium associations.
So, in reading through the provision, I guess trying to distill all that, you raised, there's really two separate arguments on appeal. One is when the court granted the attorney's fees, they went through as to the actual under C that says cost of enforcement. If you look at that provision, the provision in the master declaration does allow for fees if there's a non-complying party. And as I hear your argument, Mr. Hanson, you're saying in this case, we were not in violation of anything. We did not, there was no failure to comply. What we simply attempted to do is bring a declaration action suit seeking the court to basically do two things: declare our rights and perhaps right this quote-unquote wrong because of the disparity. So as I hear your argument saying, because it has to be strictly construed and it is in derogation of common law, under that provision about the cost of enforcement, the trial court respectfully got it wrong because we are not non-complying party. We are simply trying to ask the court to enforce, to declare our rights. Is that basically your argument?
That's exactly it, Your Honor. It's the result of the scheme of development, the departure from Chapter 718. That's where sort of this dichotomy is. There's no easy fix for it, but the fix that was presented was inequity. So there's this provision, Article 9A, if you look at it, that provides for damages or injunctive relief. There's one count for injunctive relief, but beyond that, you're right, there is no breach alleged by the developer. There's no counterclaim by the developer alleging a breach of the appellants. The appellees did not allege non-compliance by the appellants.
And I understand all that, but help me out, Mr. Hanson, with the last argument that was made by the other side, where in your complaint, you did raise under two provisions that the master declaration basically was in violation of 718.301. So the argument that has been made by virtue of your alleging that provision has a fee provision that the court ultimately got it right by awarding fees under that statute because you're claiming or you're making the argument that there was a violation of that statute. How do you respond to that?
Yes, Your Honor. First of all, that particular statute was not raised until appeal. It was not raised in the lower court proceeding. To the extent that would have any application, we believe it doesn't apply. There would need to be an allocation of fees to that statute. And there was a minuscule amount of time and effort in litigating anything to do with that. But having said that, there was, again, no opportunity for an allocation that would otherwise need to occur.
You're making the argument that it's not really preserved, that's really not an issue. Your focus is more to that first part, that under that provision, there's never been a non-compliance that would justify the award of attorney's fees by the court.
Right. That's the thrust of the argument as to the Article 9C. But I did want to, there's a couple other points I'd like to make on the 718-3026 and 718-301. Again, the complaint didn't seek to say, well, there needs to be a vote, an election to turn over control to elect unit owners other than the developer to the board of directors of SK2. So that wasn't alleged. So in terms of compliance, it wasn't direct compliance. It was the effect of the developer retaining certain rights, including the right to assign budgetary and other rights, is in itself a departure from the traditional requirements of Chapter 718. There is a difference.
Was there any part of the argument that was made here in the DEC action or as to any of the counts that sought to enforce any provision of the master agreement?
I would say no.
Well, it has to be no for you to win, right?
Yeah, well, it has to be no, and I believe it is no, Your Honor, because...
Because I'm going to ask that same question to your friend, right? In any way were you seeking enforcement of any provision of the existing master agreement? Because that's your threshold question, isn't it?
Well, I think the threshold, I'd frame it slightly differently, Your Honor.
Well, it's the first part of the provision sentence, right?
The first part of the provision.
Sub C, right?
Right, so you've got violation, but then it follows as to a non-compliant
non-complying is the second part of it.
Second part, and then that part's further clarified. If you look at the last sentence of section Article 9C, where it says that that all such costs of enforcement against a non-compliant party shall constitute a charge and continuing lien against such non-compliant party interest, if any, in the master property, as well as an individual and personal obligation of such breaching party. So that to me is where the clarification comes, to the extent there's an ambiguity. There was an ambiguity, it had to be construed against the developer, but that's the clarifying. Then you couple that, Your Honor, with the jury trial provision that's much broader, as well as...
What's the title of subsection C?
Sir?
What is the title of subsection C?
Subsection C?
Costs of enforcement, right?
Well, it's costs of enforcement, that's right.
And you weren't seeking enforcement, is your argument. So...
No, we weren't seeking enforcement, we're seeking to...
So the intent of the provision, the intent of the provision is, you're arguing that the trial court put a round peg into a square hole here.
That's exactly it, Your Honor. Well, due respect to the trial court, great respect,
but
that's exactly what it is.
Don't get bogged down probably in all those statutes. We have to look at the language here of which it was awarded, and that's where our analysis is.
Right. And if you look at subsection M, that pertains to the jury trial waiver, there's a whole host of things. Their interpretation, construction, including enforcement or performance. All those things are things that could have been in the fee provision but are not. Expressio unius doctrine applies there. And then we have the general restrictions, the signs, the nuisance, the pets, the parking, the hazardous substances. All are things that could, in the proper case, constitute a violation of the documents and more importantly, non-compliance and a breach of the documents that would invoke the attorney fee provision in Article 9C.
And Mr. Hanser, I apologize. You may have asked for rebuttal time. I forgot to write it down. How much time did you need?
I didn't ask for it. I thought about it, but I didn't express it. 3 minutes, perhaps?
Good. Well, I'm glad, because I thought I was kind of, because I didn't have anything written down, so I thought maybe I missed it. No, you're still fine. You've already exhausted almost 14 minutes, so you can still go forward
very
if
well.
you like.
And so, again, I think we've covered most of it, but the provision we submit is not ambiguous, Your Honors. Therefore, it's to be construed in accordance with its plain meaning. The developer has essentially conceded the fact that the provision is not ambiguous in their answer brief. And essentially what the developer is attempting to do is cast this as a prevailing party attorney fee provision, that we've had to defend this, we prevailed in the case, therefore we're entitled to fees. And I suggest to the court that the provision doesn't apply for that. This court previously denied fees on appeal of the plenary appeal of the summary judgment on the same basis, and I submit correctly doing so.
Let me ask you a question. The provision in the master declaration doesn't say prevailing party. It says non-complying party.
Exactly, Your Honor, and that's my point. I'm trying to draw that distinction, is that in a prevailing party case, for example, very customary, any litigation arising out of the terms of the contract, the prevailing party shall be entitled to fees. There's a whole body of case law on how you interpret prevailing party. This provision doesn't have that. It's not that broad.
The drafter presumed that whoever brought the action would be successful, I guess. That's the way it reads.
Well, yes, prevailing parties are just by their nature much broader because they prevail in the action. The action could mean anything from enforcement of a breach to an interpretation to any form of action in any way touching on the document. So prevailing party standards are just typically broader standards for attorney fee provision than what's provided in Article 9C.
Because they could have very easily, with your deck action that you filed, they could have filed a cross-claim for, to enforce the terms of the declaration. They could have proceeded with that. So if they would have filed a counterclaim, and if they, at the very end of that, the court could have, under that provision, if they would have prevailed on the counterclaim, granted fees against you, because then they would have, if their argument is that you failed to comply, that there's a suit for compliance, it'll be another story. But here, there was no such thing. You just simply filed the deck action saying, we're unsure of our rights, we think there's a problem here, help us out, court.
Yes.
And
That's
then this is
right,
the
Your Honor.
provision.
Right,
Okay.
and had they filed a counterclaim that alleged noncompliance and or a breach, those terms are essentially used interchangeably, then yes, it could have been a different analysis as to their counterclaim perhaps, and you get into that.
All right, Mr. Hanson, I'm going to save you the remainder of time for
Thank you, Your Honor.
remarks. Thank you.
May it please the court, Alex Quimby on behalf of NSCSE, Siesta Key. And
Mr. Quinn, I think you hear that if you look at the provision, because basically what Mr. Hanson is arguing is that they filed, this is not your typical situation where you have one party, there's a suit to enforce the terms of the declaration or suit to compel compliance with that. This is simply the other side filing a deck action with the court. The court came to its resolution, and then as a result of that, the court used that provision to award fees in favor of your clients. And if you look at that provision makes it very clear that you have to have a non-complying party, and then, as Judge Baldamenti indicated, enforcement of a declaration. So how do you respond to that for me?
thank you, Your Honor. So the fee provision at issue here, Article 9C, there's basically two components. The first question is, when is it triggered? The Florida Supreme Court in Careers USA 1998 decision talked about when a fee provision is triggered and talked about how a defendant can be the enforcing party. So that's the first component.
Okay, so enforcement, and zero in on the terms that you use, because a whole bunch of cases
Sure.
that you've cited to deal with enforcement,
Yes.
and that's the operative, or violation, or
Right.
compliance. So
Sure.
let's just we have to be careful, because here we're not dealing, it would be different if you would have filed suit. I guess I'm saying they failed to comply. We need to enforce this master declaration against them. There was nothing like that in this case.
Yes, Your Honor, and so I'll explain how they are a non-complying party. I just do want to point out, and this gets into the case, is that the question of when it's triggered deals with enforcement. The non-complying party simply clarifies who is paying the fees when there's an enforcement action. As far as them being a non-complying party, it's important to look at the context of what this lawsuit was about. Describing this as a mere declaratory action to determine our rights, that is not at all what this case was, and that's what the final judgment recognized by the trial court. The relief that SK2, is the shorthand reference I'll use, was seeking in this action was to destroy the governing documents that govern these two condominiums. These are two condos on the same resort property. SK1, the first condo, has 11 units. SK2, the second condo, has 33 units, and they have shared areas, and they're both subject to this master declaration that governs their rights. When SK2 filed this action, the plan was to destroy the governing documents and try to strip rights from Siesta Key, my client, and SK1 and transfer those to SK2, when the trial court even recognized that in its final judgment. The entire purpose of this was to not comply with the master declaration and the governing documents. It was to rewrite these. The Careers USA decision I referenced from the Florida Supreme Court, they say that in looking at these fee provisions, including one for enforcement like this, courts need to look at the true nature of the relief sought. The true nature of the relief sought here was threefold. They asserted claims for declaratory judgment, injunctive relief, and reformation, but every claim sought the same thing. Every claim said these governing documents are invalid. Every single claim said the trial court should force SK1 and SK2 to merge together, despite that the governing documents have specific provisions on when the condominiums can be merged.
And I understand all
Yeah.
that, but if you look at when you're dealing with attorney's fees, it is in derogation of the common law. It has to be strictly construed. And the provision that the court granted the fees were basically came to a conclusion that they're the violators, they're the non-compliance. I see what you're saying in terms of that, but it would have been a lot easier if you all would have filed a counterclaim against them saying, you know what, you all need to comply, this is the master declaration, you are, you're violating, our provision, but for simply, and I know what they're trying to get a declaratory relief from the court saying, this does not apply to us.
But Your Honor, with all due respect, that's not really what they were seeking. What the trial court recognized is they've couched their terms in a certain way to make it seem like they're seeking one thing, but the trial court referred to the crux of what they're seeking. They were trying to not comply, they did not comply with the merger provisions, and this is in the final judgment. It explicitly says each condominium has to vote for this. And one of the basis for summary judgment was the trial court said, you didn't consent, and this is from the final judgment, you did not get the consents and approvals necessary to force a merger, as the governing documents provide. They didn't comply with that. They asked the trial court to unilaterally force that. In every single one of their claims, in addition to a merger, they also asked the trial court to force an amendment to the master declaration that would create an entirely new master association to govern everybody, rearrange their rights, rewrite the governing documents. And their attorneys used the word extraordinary to describe the relief they were seeking, and it was. So they didn't comply with the amendment provisions in the master declaration, which sets forth when and how the master declaration can be amended. They asked the trial court to disregard that and to unilaterally amend the master declaration. So on the most macro level, this was non-compliance because they were trying to destroy the governing documents as they were. On a more narrow level, they didn't comply with the merger provisions, and they didn't comply with the master declaration amendment provisions. And on an even more narrow level, there's even more compliance because they specifically allege in their third amended complaint that SK2 members were attending SK1, this is the other condo, were attending SK1 meetings and demanding records. They wanted access to financial records. They wanted minute meetings. The governing documents all say you have to be a member, of course, of your association to have this type of access. So the entire purpose of this was non-compliance, both presently and in the future, to not have to comply with it. And that's why I think it's important what the Florida Supreme Court said in the Careers USA decision from 1998. They said you look at the true nature of the relief sought. They also said that you look at the force and effect of the remedy being sought. Here, this is not, they're trying to couch this, and the case law relies on this, that this is just a discrete, there's an ambiguous term in our contract. We need the court to clear up this ambiguity. They may have called it a declaratory relief action, but the trial court recognized this was not a standard DEC action or injunctive relief or reformation action. This was to completely rewrite these documents, disregard all the merger provisions, disregard all the amendment provisions, and force an entirely new plan of development that had been created by the master declaration. So,
were they in non-compliance for simply asking the court for whether or not they needed to comply with that provision, assuming that's a fair way to frame what they were trying to do?
Yes, Your Honor, they were non-complying because, quite simply, they were required to comply with the merger provisions to get a merger. They did not. They were required to comply with the Master Declaration Amendment provisions, and they did not. And they attempted to circumvent that. And the trial court noted that you can't strip these parties of their rights, including Siesta Key. You can't try to force a merger when you haven't even obtained the consents that these documents clearly provide for. So they are a non-complying party. And again, to be clear, even though they are a non-complying party and therefore it applies, that's only concerning who's actually paying these. If you look at all the cases, what they're focused on is when is the entitlement portion. This is, Your Honor, what you focused on earlier, that when is it actually triggered? Entitlement is what it begins with. And the Careers USA case there, it was a defendant defending a declaratory relief action and a reformation action, just like this case. And the trial court said the defendant was trying to uphold this contract, therefore they are the enforcing party. They're the the fees provision was triggered by enforcement. This court in a second DCA decision, and this is Barry Cohen, this is a second DCA decision from 1992, there a client sued his attorney. It was a declaratory relief action, but he sought to void their contract. So similar to this case, you can call it a declaratory relief action, but he was trying to destroy the contract. And this court held...
But in each of those cases, though, there's very definitive that there was, violation. There was issue as to compliance. There was, these are all different. And I know what you're saying, but your argument is basically, as I see it, circular. They brought this deck action, because they don't want to comply, because they brought this deck action, versus if you look at the deck action, they're like, we don't think this should apply because this is fundamentally unfair. They haven't violated those yet, and if your provision that allows for fees says there has to be non-compliance, which means a violation of our thing, so you're saying by virtue of the fact that they brought in, it's kind of non-compliance, and because they're non-compliance, we're entitled to fees. It's almost like a circular way. And so anytime somebody brings a challenge, when I say challenge, somebody brings, I'm unsure of my rights, Judge, help set this clear. You're in non-compliance. That's where I'm having a hard time. And all the cases that you cite to, they say what you indicate they say, but those are different because there's clearly factual things there that takes it away from there. This is where I'm having a bit of a hard time.
Right, Your Honor, and one of the cases they cite, the Dan Galasso decision, they raised the same concern. We don't want to turn every declaratory judgment action into a breach. Suddenly you breach, and I understand that. But that is not this case, and the fee provision in Dan Galasso and the other case they rely on, Chesterfield, are completely different. In both of those cases, the entitlement, again, in our case, entitlement is triggered by enforcement. In each of those cases, entitlement was explicitly triggered by the event of a breach or the event of a default. That's what the court was focusing on there. They weren't addressing whether this was an enforcement action. The cases that have addressed enforcement have said defending a case like this is enforcement. This fee provision in Article 9C is not triggered by a non-complying party or a violation. It's triggered by enforcement. The question is, well, who pays those fees? One of the cases they...
Well, it's the choice of words that's troublesome for you. So who is the non-complying party here? Who didn't comply?
So SK2 is a non-complying party, Your Honor. They didn't comply with the merger provisions, and the trial court recognized that when they said you didn't get the consents.
Okay, and then stop right there.
Yes,
How
Your
did they not comply? By just simply bringing it to the court saying, help us out? We have this disparity, explain what we need to do. It would have been very different.
If it said prevailing party, we'd have a different conversation, but the choice of words
Correct.
are troublesome for you.
And it would be a different thing if you would have filed a counterclaim saying, by virtue of them bringing this, they're asking you, Judge, they're non-compliance, that would have been a different situation. This is where I'm struggling with it.
Sure, Your Honor. And one point to make, and I'll address that specifically, but to keep in mind here is that SK2, and I don't believe this was mentioned in the opening argument, sought attorney's fees in this case as well in every single claim of every single one of their 4 claims. And in fact, in at least three previous iterations of the complaint, they also sought fees. So there was no question that both sides were seeking fees here. Obviously, they've abandoned that now, and that's interesting because in the Careers USA case, the Florida Supreme Court in that case noted in a footnote that the unsuccessful tenant there had sought fees throughout the lower court, and they said, we wonder if, we question whether they would be making the same argument had they prevailed. The fact, Judge Morris, that this doesn't have prevailing party language, that doesn't change the fact that it applies, because in the Barry Cohen case, the second DCA decision I mentioned there was no prevailing party provision. It was triggered by enforcement of the contracted issue there, or retainer agreement, and the court determined that there was an award of fees properly going to the defendant who upheld the validity of the contracted issue there, even though there was no prevailing party provision.
What is is there a factual finding by Judge Carroll here of noncompliance?
Well, so in the final judgment, Judge Carroll does, he states in the final judgment that they did not obtain the consents and the approvals necessary. He recognizes, or he states that they were trying to invalidate both of these both of these condominiums. Did he use the word noncompliance? I'm not sure whether he used the word noncompliance, but again, you have to look at, this is what the Supreme Court tells us in Careers USA, you look at the nature of what was going on in this case. The nature here, again, this is not a declaratory relief action for an ambiguous term. This is destroy the whole plan, disregard the merger provisions, disregard the amendment provisions.
And I guess that's where we need to look at it, because in reviewing this, it appears to me that we need you, trial court, to resolve this, because this seems to be grossly unfair to us, in a nutshell, that we're concerned with this. So please declare our rights. So the judge came and said, based on this, you have to do this. And so the question, which I think Judge Baldamenti asked, is a brilliant one, because is there a finding of noncompliance? And by virtue of what you indicated, anyone could see what the judge is doing is declaring, here's your rights, SK, this is what you have asked. No, you need to do this. So that's where it comes down to what Judge Morris also said, the words that use, the terms that you're going through is noncompliance. That's the operative term. So that's where
yes, Sharon.
we see things.
And so in upholding the validity of the governing documents of plan and development, the trial court did find, again, I don't want to misrepresent, I don't believe he used the term noncompliance, but he did explicitly recognize that they did not obtain the consents and approvals required by the governing documents and required by the Condo Act enforcing a merger. That is an explicit finding. And that's also explicitly pointed out in the third amended complaint, the operative pleading here. They specifically say, we can't get the consents, so we're going to seek a merger. And again, this same argument applies to the amendment provisions. It applies to the fact that the master declaration lays out ways that you can terminate the master declaration. None of those were followed. In addition, there is a factual component in a more narrow sense of noncompliance. They point out, this is on the face of their third amended complaint, that they attended these meetings and were kicked out when they were trying to get records, trying to get meeting minutes, trying to get financial records. All that on the face of the third amended complaint and on the face of the attachments to it, which includes all the condominium documents, is noncompliance. So for that reason, Your Honor, we would ask you to affirm. They are non-complying parties under this. And again, the point of noncompliance, I do think it's a distinction that matters. It doesn't deal with when entitlement is triggered. It's simply who pays it. So it doesn't require an explicit finding as to that. So they are the non-complying parties here. I mentioned that the cases they rely on, which are the Dan Galasso case in Chesterfield, there the language specifically focused on in the event of a breach. That's not what we have here. And I also think it's important for the court to look at the Silver Blue Lakes case. This is a decision we cited from the third DCA. Here you had a lessor that unsuccessfully sued the lessee. That was a declaratory judgment action regarding interpretation of the lease. So much more limited than our case, where they're trying to, blow up the whole system. This was actually interpretation of the lease. And there, the provision in the lease said, if by reason of the default of the lessor and the performance of any of the lessor's obligations, and it went on to say that in that context, the lessor would owe fees. There was no explicit finding of a default there, and the third DCA awarded fees to the prevailing lessee in that situation. Our case goes much further, again, because here we have on the face of the final judgment and on the face of the third amendment complaint, non-compliance with various provisions of the governing documents. As far as the actually interpreting the provisions, Your Honor, you pointed out, construing this as an abrogation of common law. I would note that what the cases actually say, and this is the case they cited, the Sholkoff v. Boca Raton case, this concept of construing a fee provision against the party trying to enforce it, again, it's the case they cited from the fourth DCA. It actually goes through the analysis and says that case law is based on a statute that abrogates the common law and how that needs to be clear and things of that nature. It doesn't actually apply to a contract. It says, basically, why would a contract provision for fees be interpreted any different than any other contract provision? So I would point that out. They also cite several cases to say that, if the provision is ambiguous, that it has to be construed against us. Once again, those cases, Washingtonian and two others, we pointed this out in our answer brief, they actually deal with a substantial ambiguity. The question is, there is substantial ambiguity here. We contend there is not. Again, on the face of it, it's clear that the entitlement to fees arose under both the previous second DCA decision I referenced in Careers USA. The second question is, does it apply to SK2? Could they be a non-complying party? Not whether entitlement is triggered, but could they be a non-complying party? And in the face of the final judgment and the third amended complaint, they're not a compliant party. So for that,
Mr. Grossens, you're right at your 20 minutes. If
Okay.
you want to just quickly wrap it up.
Sure, thank you, Your Honor. So for that reason, we would ask the court to affirm because the trial court correctly found for fees under Article 9. Thank you.
Very good. Thank you, Mr. Grossens.
Okay, briefly on rebuttal, the question asked by the court in terms of the amendment, the noncompliance. There was no finding of noncompliance. Moreover, there was no allegation of noncompliance by the developer. There's no counterclaim. And the Del Galasso Waste Services case addresses this issue, I believe, succinctly. In that case, there was a order on review because there was plaintiff was not in breach of the agreement, was not the breaching party, hence the fee provision did not apply. There's no fees awarded. And then the court goes on to state, simply by incorrectly perceiving its legal rights under the contract and bringing an action to enforce those rights as it perceived them, plaintiff was not as urged in breach of the agreement, else every unsuccessful action for breach of a contract would itself become breach of a contract. And then stated differently, the plaintiff committed no actionable breach of the contract by misperceiving its rights under the contract in unsuccessfully bringing an action to enforce them. Well, that was actually an action for enforcement. Here, there's an amendment provision, but there's no, that's where the argument gets circular. There's no obligation to seek an amendment. It's not a non-compliance. In other words, SK2 didn't breach the agreement by not seeking an amendment. There's also a question of whether the amendatory provisions would apply or instead Section 718.110.4 Florida Condominium Act because of the nature of the rights of the parties and even non-parties to the extent mortgagees are involved. So there's some complicated legal issues there, but certainly I don't believe that was even pled. If it was, there was no finding as to that, and certainly no obligation on the part of the association for the SK2 to have sought an amendment, and certainly is not in violation of the documents or in non-compliance for not seeking an amendment. I believe that was an observation by the court as to that. The Cohen case was abrogated by the Florida Supreme Court case in very limited precedential value. And again, the Silver Blue and those other cases are very different, distinct. I think Your Honor noticed that they resulted in specific monetary rights under the particular contracts in that case. So I think here, Your Honors, there's enough certainly to deal with this on a de novo basis. The court has previously done just that in the previous ruling on appeal, denying appellate fees in this case on the same basis that the developer is asserting here, and based upon the narrow and unambiguous terms of the contract provision in 10.4, submit that the fee should not be awarded. My client shouldn't be punished for attempting to right this wrong, and that the action should be reversed as to the final judgment for fees.
Very good. Thank you both. Again, very well argued. Thank you.